Alrighty, y'all. This is This We the People News. This video is without prejudice and or without recourse. Alright, I'm going to go ahead and stand on the UCC 1-308. All rights reserved. Okay? I'm not an attorney, so anything I say or do is just my opinion only. Why? Because I'm not an attorney. I do not practice law. I'm not bound to the bar union. Alright? I try to stay away from that as far as possible because I don't want to enter any contract that bounds me to own slaves. Alright? I never just look straight forward. Always look around me to be able to protect myself by any means necessary. And this is one of the best ones, this guy here, where the storm clouds are gathering, right? I wished I can just have his memory span, y'all. And once or twice before I said I'm jealous. I'm not jealous. It is what it is. So I used incorrect words. Okay? I cannot be jealous what another man has. That is a sin, according to my religion. Okay? It is what it is. However, I can honor the man of the knowledge he does have. Alright, let's finish this up. What do you guys think?
Title of nobility, nor confer hereditary distinctions. That's Article 1, Section 35 of the Bill of Rights. The General Assembly shall not grant any titles of nobility. Where do you think they got that from? The original 13th Amendment. Ladies and gentlemen, it's very much alive, very much well. I don't give a fuck if they burn it. Makes no difference to me. And to prove that it was ratified and passed by the majority of the states, it's in the Nebraska State Constitution. So how the fuck did the original 13th Amendment to the Constitution find its way into Nebraska's organic Constitution if it wasn't ratified by the 13 other states? Food for thought. All right, just think about that shit. Number 37, Article 1, Section 37, there shall be neither slavery nor involuntary servitude. You know where that comes from? Treaty again. All right, that's why the war kicked off. Abraham Lincoln said he was going to free the slaves. He didn't have a fucking choice. He either did that and he honored the Treaty of Ghent, or he was excommunicato in international trade and commerce for violating the treaty. He would have been an international dishonor, and he wouldn't have been able to borrow funds from any foreign country because he would have broken a treaty. And when he broke that treaty, if he had broke the Treaty of Ghent, then there would have been no financial flow in the United States of America anymore. So it's important to know that. And it's found in every constitution. All right, this one happens to be the Bill of Rights of Indiana. Article 1, Section 37, there shall be neither slavery nor involuntary servitude with the state, otherwise than for punishment of crimes whereof the party shall have been duly convicted. Now, when you're being subpoenaed or summoned or whatever to court, don't you have a right to be fucking paid? You're innocent until proven guilty, right? What crime have you committed? Is there a man or woman claiming harm, injury, damage, or loss? No, there is not. Not 90% of the fucking cases. Not 90% of the fucking cases. There is no injured party. So, ladies and gentlemen, bill the motherfuckers. Bill them up. Hit them for $1.5 million. Don't be scared. Just hit them with it. Who gives a shit? Okay. Respondent accepts and acknowledges. Those are the key words right there. Accepts and acknowledges. This is the Title 5 3331 oath. I'm looking for the specific oath. Here we go. Respondent invokes, accepts, and acknowledges. Karen Lynn Noakes. Title 28, USC, subsection 453, Oath of Justice and Judges. I, Karen Lynn Noakes, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all duties incumbent upon me as Nebraska, whatever, Custer County Circuit Court judge under the Constitution and laws of the United States. And then, of course, the So Help Me God, there's no religious requirement for taking an oath, so it's really their choice whether or not they want to do this. So Help Me God. But here we go again. Respondent invokes, accepts, and acknowledges.
You can go ahead and accept the oath as it is. However, if it's not in the law, then that oath would be unlawful if it's added to it, right? You cannot add or subtract from a contract, or treaty or anything like that, right? So if the law specifically says that it don't have "so help me God" and they add it in there, they broke the law.
Just remember, we're invoking, we're accepting, and we're acknowledging. We are binding them.
Just for argument's sake, y'all. Now, if they said sign that paper and it don't have "so help me God," but they did say "so help me God" when they were doing it, that's fine, as long as it's not on paper.
Knowingly, willingly, intentionally. First time was happenstance. First time was coincidence. Second time was happenstance. Third time's affirmative. Knowingly, willingly, and intentionally. All right. So, respondent invokes, accepts, and acknowledges. Karen Lynn Noakes, Title IV, USC, subsection 101 oath. I, Karen Lynn Noakes, do solemnly swear that I will support the Constitution of the United States. That's how simple the oath was when it first was created. I, the name, do solemnly swear that I will support the Constitution of the United States. That's it. Nothing more.
That is it. Why are they not filling out that Article 6 for Section 101? That is all. It is unbelievable how they ignore that one. Why? Because they're bound to the Constitution.
Not against all enemies, foreign and domestic. Remember, that's the Title 5 3331 oath for profit. Okay? Now, let's get back to the lesson at hand. The state shall swear to protect and defend the Constitution from all enemies, foreign and domestic, and he will perform his duties to the best of his ability, so help him God. American Jurisprudence, Section 177, declaratory judgments. Now, declaratory judgments are what men get, all right? Lawyers can't get declaratory.
Okay, and I'm going to clear something up. The Article 6 for UCC 0101, the federal Constitution don't have "so help me God," but if it's actually in the state laws of the state Constitution, that is okay. Okay, so let me just kind of clear that up, y'all. But they must y'all, have the Article 6 for Section 101. They must have that with their full legal birth name. All right, it's not Donald J. Trump. It's got to be Donald John Trump, right? It's just an example, okay? That's just a name that just popped off on top of my head, right? The other ones in the states, you're going to have to look up your laws on that particular oath of office.
Judgments. I had a lawyer tell me one time, Derek, that's old law. We don't use that anymore. I know why you can't use it, and I know why you don't use it, because you can't get a declaratory judgment because you have no first-hand knowledge of the fucking facts. That's why lawyers can't get a declaratory judgment. They only get summary judgments, all right? Declaratory judgment actions have often been utilized to test the constitutionality of a statute and government practices. The Uniform Declaratory Judgment Act makes specific provisions of the determination of construction or validity of statutes or municipal ordinances by declaratory judgment and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statute and of ordinances. The Federal Declaratory Judgment Act has been invoked frequently as means of assaying the...
Now, ordinance, okay, American jurisprudence, and I guess he's not going to bring this up, which he probably knows, probably don't know, I don't know. But American jurisprudence, ordinance, is a member of a corporation, okay? So, the courthouse is a member of the corporation, all right? They got an ordinance, okay? But that does not apply to me, okay? Well, you must obey city ordinance. No, I'm not a member of y'all's corporation.
Constitution of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. The court may grant declaratory relief unless there is a case in controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the education. You have a right to demand a declaratory judgment. Remember, men make claims, men get declaratory judgments, corporations file complaints, corporations get summary judgments, okay? So men make claims, they get declaratory judgments, and men don't have to pay for their right to redress their grievance in a court, okay? And corporations have to pay for the court's time because it's a privilege of the corporation to be able to go in there and argue how they've been caused harm, damage, injury, or loss through a lawyer, okay? And because it's a privilege, they have to pay for it. But we have a right to go into those courthouses, and we have a right to get a docket number, and we have a right to redress our grievances, and we have a right to justice, all right? Remember, justice delayed is justice fucking denied. If it's delayed for a half a fucking second, that's justice fucking denied, all right? What's right is right, what's wrong is wrong. It's black and fucking white. It doesn't get any sweeter than a Skeeter's fucking Peter, all right? It's right there, gnat's ass, fine as frog's hair, all right? So, stay with me here. We keep going. 16 Am Jurisprudence, Section 255. In all instances, when the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. I can't say that word. Irreconcilable. The court is without authority to declare a statute unconstitutional unless it is in positive or in direct conflict with the statute or with the Constitution. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof, because that would be a violating the Constitution. Marbury versus Madison, a clear incompatibility between law and the Constitution must exist before the judiciary is justified in holding the law unconstitutional. This principle, of course, is in line with the rule that doubts in the constitutionality should be resolved in favor of the constitutionality and the beneficiary, which would be you, ladies and gentlemen. This fly's about to die. He's about seen better days. American Jurisprudence 256. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is reality no law at all, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of the enactment, not merely the date of the decision so branding it. An unconstitutional law in legal contemplation is also inoperative as if it had never been passed. Such a statute leaves a question that it purports to settle just as it would be had the statute not ever been enacted. No repeal or enactment is necessary since an unconstitutional law is void. The general principle follows that it imposes no duties, coffers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. That's what I covered, ladies and gentlemen, last Saturday in the class on warrants. Dare to discover the truth and live free, or die trying. When warrants aren't issued properly, nobody's protected by them. And if you know your rights and you know the law and you know what needs to be in a warrant, ladies and gentlemen, I'm telling you, 98% of the warrants that are out there are ineffective, they're defective, they do not have the proper criteria, they do not meet the proper elements of a warrant, okay? A warrant of committal.
For a short instance, right? A warrant has got 5 elements in that warrant. All 5 of them must be there. Be a true and correct warrant. And it's got to follow the guidelines, what it says it has to be done. All right? Just like the Second Amendment. It's got 4 separate elements in the Second Amendment. Everybody bypasses that.
And because of that, there's no obligation to obey. There's no obligation to enforce. And I also go into on that class on how you hold them liable and who you're going to hold liable, because it's not who you think you would be holding liable. Actually, it's way different. And it actually took me off my feet when I realized who becomes a liable party, even though the judge signed it. Doesn't matter. Even though the clerk of the court may have signed it, doesn't matter. Even though there's a court seal on the warrant. Doesn't matter. There is somebody else that gets held liable for their dereliction of duty because they had a duty to know. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under the statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if the repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. Where a clause repealing a prior law is inserted in the act, which act in unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. The general principle stated above applies to the Constitution as well as the laws of the several states, insofar as they are repugnant to the Constitution and the laws of the United States. Moreover, a construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had in its express terms been enacted in conflict therewith. Anything passed in conflict with the Constitution is clearly unconstitutional. Am Jurisprudence 257, the actual existence of a statute prior to the determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested of status or prior determinations deemed to have finality and acted upon accordingly, and of public policy in light of the nature both of the statutes and of its previous application demand examination. It has been said that an all-inclusive statement of the principles of absolute retroactive invalidity cannot be justified. It would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have an indeterminate consequences binding upon the people. Am Jurisprudence 258. On the other hand, it is clear that Congress cannot, by authorization or ratification, give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. Am Juris 260. Although it is manifest that an unconstitutional provision in the statute is not cured because it's included in the same act with valid provisions, and that there are no degrees of constitutionality, so that an act is either constitutional or it is unconstitutional. So if you have a statute that is partially constitutional and partially unconstitutional, it is all in its entirety unfucking constitutional, ladies and gentlemen. We cannot pluck the good out of the bad and go, okay, we're going to throw the bad over here, but we're going to hang on to this. If one part of it is wrong, it's all fucking wrong. Just like in a contract. You can't cherry pick what's good out of a contract and go, well, we're going to abide by this and we'll disregard all this bad shit. No, that's a new contract, all right? And that means that the original contract is void in ab initio, all right? So, thank you for joining me, ladies and gentlemen. I just wanted to, we got a couple more paragraphs here before we get to the next segment. All right. For the last half hour, I've been trying to hammer home the power of this book, the Constitution. If you know what's in the book, I'm telling you that you are in full possession of your American citizenship. If you don't know what's in this book, you are going to be a slave, subject to the whim of extrajudicial people who want to tell you what to do, when to do it, how to do it, and how high to pack it. Learn your book, know your arguments backwards and forwards. Don't let somebody come and tell you what is not the law. Don't let them tell you that you don't have any rights. I love it when these guys tell me I don't have any rights. I say, well, if you believe that, let's go to court. And at the end of the day, we'll see who owns who. But I'm going to tell you right now that if you violate any of my constitutional protected rights, I will sue your socks off and attach everything you have, bank, business, and home. So thanks again for joining me. Thanks for all your support. We've got another class coming up here.
And he says that, but that's what I've been saying, right? You give them a notice of trespass. Like the First Amendment auditors, they come over here and they start demanding things, right? All right, well, this is your notice of trespass. Do not trespass upon any of my rights, especially y'all's number one Constitution. Do not trespass upon that, right? I told you guys before that I had a brother actually towed what do you call them? Gee Louise, blanked out of my head. Them officers of the court, right? Judge told him that hold him in contempt and grab my brother. My brother actually pointed his finger at that bailiff, right? And said, "Don't you dare trespass upon my rights." And they stopped. They just stopped in midair. They looked at him and looked at the judge, and they were stuck. They didn't know what to do. It's so freaking funny. They did go into pause, but while the judge was trying to figure out what in the world is he going to do. All right, and just a reminder, y'all. And he said it too, when a judge says contempt of court, you challenge it, right? Is it civil or criminal? Okay? Civil, he's offering a contract. There's an offer. If you want to grant that offer, fine. Well, give me $25,000 per minute that I'm setting under duress. I'll accept that offer. Or, if it's criminal, that judge or clerk or whatever you want to call him or her, right, cannot be judge, jury, executioner if you committed a crime against that judge, right? Now he's the complainant. Well, there had to be another judge to actually deal with the situation at hand. All right.
In the next few weeks, I'll announce it and give a date and a time and how you can contribute. And we're going to be dealing with repairing your credit, the proper way of going about it. And I think everybody should really chime into that class. We're also going to dive into some other pertinent parts because there are people that go out there and they just remove things from their credit report. Why do that? Why remove an asset from your credit report? Show it paid, timely, in good standing, and paid in full, and add an asset to your credit report instead of removing something from it. Show it paid in full. I'm going to show you guys how to do that. So thanks for joining me. Appreciate all your love and support and kind words and prayers. It means a lot to me, and we'll talk to you real soon.
All right. Where the storm clouds are gathering, y'all. His other YouTube channel, if you're interested in his earlier days, is Derek with 2 R's and Gonzalez. Okay, so check that out. I don't know. There's I really like him. So this will be the People News, y'all. Till next time, bye.